Welcome to Crime Before Modern Law. Here, we explore how crime and justice functioned before modern policing. If you find this topic interesting, feel free to leave a comment telling us where you are watching from. And if you would like to support the channel, a like or subscription always helps. When people hear the word investigator, they often picture a modern police detective, someone trained to interview witnesses, collect physical evidence, and build a case for a public prosecutor. Ancient societies did not have that exact job, but many of them still had ways to find out what happened, identify suspects, and decide who should be punished. In this documentary-style explanation, we will look at early investigation before modern policing. We will focus on how ancient communities gathered information, who had the authority to question people, and what kinds of evidence counted. The main idea is simple. Investigation existed, but it was usually tied to courts, local officials, family responsibility, and social rank, not to a separate professional police department. First, it helps to define what investigation means in an ancient setting. In many ancient places, there was no single agency that patrolled streets, responded to crimes, and investigated them full-time. Instead, investigation was often a process inside the justice system, not a separate stage before the courts. The steps might include a complaint, a summons, a hearing, and then a decision. The same officials who ran the court might also do the questioning and fact-finding. Also, many ancient legal systems relied heavily on confession, oaths, witnesses, and social reputation. That changes what investigation looks like. If a society believes that an oath before a god is strong proof, then the key step is getting someone to swear the oath. If a society believes that punishment should happen quickly to restore order, then long evidence gathering may not be a priority. With that in mind, we can break early investigation into several common tools used across ancient societies. 1. Complaint-driven justice. In many ancient systems, the state did not start cases on its own very often. A wronged person or family member had to bring the complaint. That person might also be responsible for identifying suspects and presenting evidence. This is very different from modern policing, where the government can investigate crimes without waiting for the victim to do the work. In ancient communities, if you did not have family support, money, or social standing, it could be much harder to push a case forward. 2. Witnesses and sworn statements. In a world without cameras, fingerprints, or databases, people relied on human testimony. Witnesses mattered, and false witnesses could be punished. Written documents also mattered when they existed, especially in societies with trained scribes. 3. Physical inspection, but in a simpler form. Ancient officials did look at bodies, wounds, damaged property, or stolen items. They might visit a site, examine injuries, or check boundaries. But these were not modern forensic methods. They were practical observations meant to support a decision. 4. Community knowledge and reputation. In small communities, many people knew each other's habits and conflicts. Investigation often meant asking neighbors what they knew. A person's reputation could help or harm them. 5. Coercion and forced testimony. In many ancient societies, torture and harsh interrogation existed, especially for enslaved people or lower-status suspects. This is a major part of how investigation sometimes worked. It was aimed at producing a confession, not carefully testing facts. 6. Religious tests and ordeals. Some legal systems used oaths, rituals, or trials by ordeal when human evidence seemed uncertain. From a modern point of view, these were not reliable ways to find truth. But within those societies, they were seen as a way for the divine world to reveal guilt or innocence. Now let us look at how these tools appeared in specific ancient civilizations. Mesopotamia. Courts, witnesses, documents, and ordeals. In ancient Mesopotamia, including Babylon, law was closely connected to courts and judges. The well-known legal traditions include rules about witnesses, written contracts, and penalties for false accusations. What matters for investigation is that proof often came from witnesses and documents. If a dispute involved property, contracts, or trade, written proof could carry great weight, and scribes played an important role. But when a case could not be settled by ordinary proof, some legal traditions allowed for ordeals, such as a river ordeal, in certain kinds of accusations. This was not investigation in the modern sense. It was a procedure meant to produce a final answer when humans could not. In practical terms, this tells us that ancient Mesopotamian justice did not always focus on reconstructing events step by step. It aimed to reach a decision using the accepted forms of proof, documents, witness testimony, oaths, and sometimes ordeal. Egypt, policing functions and administrative investigation. Ancient Egypt had officials responsible for order and security, and it also had a strong tradition of administration and record-keeping. Egyptian society depended on state officials, local administrators, and scribes. When problems arose, such as theft from tombs, disputes among workers, or conflicts over property, officials could question people, record statements, and report to higher authorities. Egypt also developed security roles tied to state power and important sites. One example often discussed is the Medjay, a group associated in later periods with policing and protection duties, especially in desert regions and in guarding important areas. For investigation, the key point is that Egypt's strength was administration, reporting, documentation, and hierarchies of authority. A case could move upward from local officials to higher ones, with written notes and summaries. However, like other ancient societies, Egypt did not have a single modern-style detective service. Investigation was attached to officials who already had other duties. Greece, citizen courts and limited state investigation. In many Greek city-states, especially classical Athens, justice relied heavily on citizen participation. Courts used juries of citizens, and cases often depended on speeches given by the two sides. This system shaped investigation in a very direct way. The state did not always conduct long fact-finding before trial. Instead, each side gathered what it could: witnesses, documents, and arguments. The court then decided. For serious crimes like homicide, Athens used special courts and procedures. There were magistrates connected to these cases, and the process could involve formal steps, including hearings before trial. Even so, Greek legal practice in many areas was not built around professional investigators. The investigation, as we might call it, was often performed by the parties involved. That meant the quality of evidence could depend on wealth, social networks, and persuasive skill. Rome, watchmen, informers, and strong judicial authority. Rome developed several institutions that looked closer to policing than many earlier systems. One important group was the vigiles. They are often described as firefighters, who also served as a night watch. Their patrols could discourage petty crime, and they could detain suspicious people at night. But Rome's approach to investigation also included something else: the use of informers and accusers. Roman society did not always have a modern public prosecutor system, and private citizens could bring accusations. Informers, sometimes called delatores, could play a major role by bringing information to authorities. This is another kind of investigation, but it works differently than modern detective work. It depends on incentives, personal rivalries, and political conditions. It can produce useful information, but it can also encourage abuse. Rome also had powerful officials with criminal jurisdiction in and around the city, such as the urban prefect. This official authority mattered because an investigation often requires the power to summon, detain, or question people. So, in Roman settings, the investigative picture is mixed. There were patrol and watch functions. There were judicial officials with strong authority. There were informers and accusers who helped drive cases forward. But there still was not a modern police department with a clear separation between patrol officers, detectives, and prosecutors. India, statecraft texts and information networks. Ancient Indian political thought included detailed discussions about governance, crime control, and intelligence gathering. One major example often discussed in scholarship is the Artha Shastra, which describes methods of administration and also places strong emphasis on networks of spies. This kind of information gathering is not the same as investigating a single murder or theft in a modern city. But it shows that some ancient states took finding out what is happening very seriously. In a system like this, the state's ability to investigate could include secret observation, testing the loyalty of officials, gathering reports about unrest and conspiracies, learning about theft, fraud, and black market behavior. This is closer to intelligence work and internal security than modern detective work. Still, it is part of early investigation, organized methods for collecting information to enforce order. China, magistrates, local runners, and later forensic tradition. Imperial Chinese justice is often described through the role of the local magistrate. The magistrate was an official who combined many roles: administrator, judge, and manager of local order. In such a system, investigation was closely tied to the court. The magistrate could question suspects, interview witnesses, and order arrests. Local staff helped carry out these tasks. In later imperial periods, there were yamen runners, low-level functionaries who could handle practical duties like serving summons, escorting prisoners, and conducting arrests and investigation work under the magistrate's direction. China is also known for an early tradition of forensic attention to wounds and causes of death, especially in later periods. A famous example is a forensic handbook written in 1247 during the Song dynasty, meant to guide officials who inspected bodies. This book is not ancient in the sense of the earliest civilizations, but it shows an important point. Systematic methods for examining evidence can grow inside a legal system long before modern police departments exist. Across these societies, we can now ask a simple question: if there were no modern detectives, who did the investigating? The answer depends on the place, but several patterns repeat. First, victims and families. In complaint-driven systems, the victim and family often did the first work. They identified suspects, gathered supporters, and brought the case. They might also negotiate settlements. Second, local officials. Where states had strong administration, local officials handled inquiry. They had the power to summon people, record statements, and apply pressure. Third, community leaders and councils. In smaller towns, councils of elders or respected leaders might question the parties and decide what happened. Fourth, specialized guards. Some societies created guards to protect key sites like palaces, temples, granaries, and city gates. Their duties could include tracking down thieves or dealing with disorder near protected locations. Fifth, informers and networks. Many states depended on information from informers, whether formal or informal. This could be helpful for learning about hidden crimes, but it could also be dangerous if rewards encouraged false accusations. Next, we can look at the investigative toolbox more closely by asking what counted as evidence. Evidence in many ancient legal systems fell into a few broad categories. Witness testimony. A witness could be the strongest proof available. The weight of a witness could depend on status, gender, citizenship, and freedom. Enslaved people's testimony was often treated differently. Documents. In societies with writing and strong record systems, documents could be key, especially in property and contract disputes. Confession. Many systems treated confession as decisive. This encouraged harsh interrogation methods. Oaths. A sworn oath could serve as proof when other evidence was missing, especially in religious societies. Visible signs. Officials might inspect wounds, damage, or stolen goods, but usually in straightforward ways. Ordeal or divine judgment. In some cases, when evidence was uncertain, ordeals acted as a final decision tool. Now we can address the main question clearly. Did ancient societies have investigators? If investigator means a trained professional detective working in a separate police agency, then usually no. But if investigator means a person or office responsible for finding facts, questioning people, inspecting places, collecting statements, and identifying suspects, then yes, many ancient societies had those functions. They just organized them differently. Investigation was often merged with judging. Investigation was often pushed forward by victims and families. Investigation often depended more on testimony, confession, and social standing than on scientific evidence. Investigation sometimes relied on coercion or religious procedures. The final point is about why these early systems looked the way they did. Modern criminal investigation depends on several things: professional training, stable funding, bureaucratic record keeping, public prosecutors, and a clear idea that the state is responsible for pursuing crime even when victims cannot. Many ancient states had parts of this, like record keeping and official authority. But they usually lacked the full combination, and they often had different goals. Their priority was often to restore order, protect property and hierarchy, and confirm authority, rather than to produce a detailed reconstruction of events. So the history of investigation is not a straight line from no investigation to modern detectives. It is a long process where societies develop different ways to answer the same basic question: what happened, who is responsible, and what should be done next. Across the ancient world, the tools were real witnesses, documents, inspections, informers, and official questioning, but they were shaped by the values and limits of their time.